Hi, everybody. Thank you and welcome to the FIA Group's exclusive, by invitation only, ICE webinar. We're going to get started now. We're 1 minute past 1 Eastern Time, according to my watch. According to my watch, I've also only gotten 1,000 steps in today. So once we're done with this, I'm going to hop up and run around the office. And one of the things that's going to energize me to do so is talking about some of the crazy stuff that's going on in our industry today. If you tune in normally to one of our webinars, you are no doubt familiar with our format. Often what we'll do is open the webinar by talking about some of the crazy stuff that's going on in the industry, some of the questions that we're receiving at PGC referral, the consulting issues. Then we go into the political issues. Usually it's Brady Bizzaro, an attorney here at the FIA Group, who will start to talk a little bit about some of the things we're seeing and predictions we have moving forward. And then we usually conclude with the actual subject matter of the webinar, whatever the topic du jour is that day. This webinar is different. This webinar is meant more to communicate directly with you rather than speak at you. And the purpose is to really talk about the issues that you've been bringing to us. As ICE clients, as entities that have retained us for these consulting services, the issues that you've brought to us that perhaps others on the call have not yet mentioned, but it might be either something that has just come up, something they haven't thought we might be able to help with, or something that hasn't come at you at all, but we predict it probably will. This is one of the benefits of ICE, is the ability to really collaborate. I look at it as almost a think tank or a brain trust where the work we do for one ICE client, independent consultation and evaluation, is really also meant to be a benefit to all of the ICE clients. And also, I think that we might have more than one presenter on the line right now. If you could potentially just mute your phone, that would be great. I'm not exactly sure who has sharing capability right now, but the quick and easy way to handle it will be to go ahead and put it on mute. If you have any questions or concerns or want us to address something or go a little bit deeper into one of these issues, what we can do is we will actually utilize the question or chat box. We'll keep track of that as we go and address the questions as they come up. And without further ado, we're going to go ahead and tell you a little bit about the people that are presenting today. You've got myself, Ron Beck. I will actually be channeling the spirit of Adam Russo. Adam is not on the phone right now. In addition, we have Jen McCormick. Jen McCormick, of course, is the vice president of our consulting team, an industry-renowned attorney, and really the head coach, the general manager, and the owner of the team. And she, not only is very capable when it comes to answering some of the questions that we receive, but she also manages those within the consulting team and ensures that the right people receive the right questions at the right time. I'm not going to tell you that we have specialists, attorneys that specialize in each of these topics, because that would not be 100% true. The goal here is to have individuals that are subject matter experts in different areas of regulatory compliance, the law, things that you need to know in order to stay abreast of all the requirements of law and regulation. But at the same time, we never want to find ourselves in a position where we may be asked a question and the individual that is best suited to answer that question is not available. That's just not the way we roll. We always make sure that everybody at the company is at least familiar with every issue or topic that we're dealing with at the time, things that are currently important, hot topics in the industry, that we can get to an answer ASAP. Mm-hmm. So without further ado, I'm going to go ahead and pass it on now to Jen and myself. We're going to explain a little bit about ICE in general. Jen, a lot of individuals that are clients of ICE, they contact us about issues or topics for which we already have services. So in a lot of ways, you could almost look at this as a supplement to a service. The first thing that comes to mind are our plan documents.
Absolutely.
Obviously, we have a lot of other services that relate to plan documents. Maybe in sort of 2 words or less, couple minutes, could you maybe explain a little bit about the plan document services and how what we're doing with ICE, this independent consultation evaluation, the things we deal with that relate to plan documents there, and some of the differences between the two, so people don't necessarily think it's 2 names for the same service.
Yeah, so obviously in my opinion it might be a little bit biased, but I obviously think that plan documents are one of the most important things of having a self-funded plan, because the plan document is the law. The plan document tells you what to do, how to do it, and when to do it. So one of the many different services that we offer here is drafting these very important, crucial documents for the groups, which is starting from drafting a whole document from scratch when there wasn't one that ever existed in the first place, or maybe there was a group that previously had a fully insured document and now they are becoming self-funded and they need a new document. We can do that as well. Or even something as small as making a modification, adding a new exclusion, or adding a new amendment to address a new benefit that might be offered. And the way that we can draft these documents, we can do this by taking a current document and using Microsoft Word to redline in changes, modify changes, or more importantly, we can do this with our PDM service, which is where you can actually log on to a website and custom create your own documents and download and produce a brand new document with the click of a button. It's just that easy. If I can do it, then anybody can do it, I'm convinced.
I don't know about that.
But as part of drafting these documents, whether it's through PDM or whether it's drafting with the Redline services or creating an amendment, there are oftentimes questions that arise as it relates to these documents about how to get it done. So you know that you need to make a change, you know you need to add a benefit, you need to modify a benefit, but how do you do it, where do you add it, and what should the language look like? It's really important to understand that when you're drafting and modifying plans, there are potential compliance concerns that need to get addressed. And as part of ICE, one of the many things that we can do is to address those questions that would arise, so you'll have all the answers that you'll need in order to draft the amendments or to draft the plans in a way that's not only going to be efficient and contain costs, but obviously compliant, which is one of the most important things to do.
I like that you just mentioned that sort of the hand-holding or the guidance, because I think in a nutshell, what we look at ICE versus other services, the other services are more products, a tool. So for instance, if you have a subscription service with PDM and you're creating your plan documents online, that's a tool that you use to create plan documents. And there is a certain amount of consultation and advice that comes with that fee, but ultimately it's somewhat limited. Whereas with ICE, it's not a tool. Rather, it's more access to individuals that understand the service, individuals that understand what you need to do, individuals who are going to provide guidance and essentially help you use that tool. So look at the difference between, you know, if you're somebody who's a DIYer and you make the same mistake I make and do work on your house rather than hiring a contractor.
No.
It's not gone well. I'll tell you right now, my father told me, you know, try to do what you can yourself, but never mess with plumbing or electric, and he was 100% correct. But anyway, look at it this way. PDM is like the actual tool itself, the toolbox, whereas ICE is like having an expert come in the house and actually work with you and assist you. In addition to that, plan documents, you know, that kind of guidance or advice, it spreads into things like ACA compliance, gap reviews. This is huge as well. We, as one of our plan services, we perform a gap review, which up until recently basically meant taking a plan document, looking at a stop-loss policy, comparing the two, and determining, do we see situations where the plan may be stuck paying something that stop-loss is not required to reimburse, exclusions, definitions, things like that, and closing the gap, basically helping everybody mirror, the plan and the stop-loss mirror each other, and it closes that gap in coverage. And it's been very successful and wonderful and helped a lot of people. But because of our work with ICE, we've actually been exposed to other issues that are impacting the self-funded community, one of which had to do with leaves of absence and employer handbooks with their employees, where individuals would be told, hey, if you're on disability, if you're on an approved leave of absence, we're going to extend coverage under our health plan for as long as you're away from the office. And that's very generous, and it's well and good, and it's within that employer's legal right to do so. But the problem is the plan document doesn't reflect that. The plan document says if you're not at work for more than 30 days, you're not actively working, you're kicked from the plan. And you either have to sign up for COBRA or you're out of here. So neither of those decisions, let them stay on the plan or kick them from the plan, are illegal. But the problem is, if you go one way, you're now contrary to the other. And so the two can't coexist. So we learned about that potential conflict, that potential issue, because of a question that an ICE client brought to us. Not only do we now have solutions for that problem because of our work with ICE, but we've moved it into our gap review service as well, where we're now looking at the employee handbook. So when we talk about the list of issues and topics that we deal with, a little bit more detailed, people ask, all right, so what do I get, what don't I get for the ICE subscription service? Review and assessment, we already mentioned. The gap review, again, the handbook is up there. Third-party contract review and commentary, red lines. This is actually one of my favorites. As much as I enjoy doing my own work, I really prefer tearing apart other people's work. I have a destructive streak. My son, he's 17 months old at this point. I see it in him too. I always build these block towers, and he just likes to tear them down. And I realize that's what I'm doing to these administrative service agreements, network contracts, direct provider agreements. You name it, we'll look at it. Another big one, and thank you, industry. We've had a lot of innovative vendors starting to appear in our industry at conferences, and they offer amazing services, and they give you these contracts, and you can't make heads or tails of it. Not only because the contract is confusing, but because the service to which it relates is a new service. So there's no history. There's no other contract you can compare it to. It's an island on its own. And so you're looking for somebody to review it and point out potential issues and problems. Reviewing those kind of third-party contracts is another service we're providing.
That's also something that's really important now, Ron, when we're talking about these third-party agreements. There's actually been a bunch of litigation recently. I can't help myself but talk about as UL audit. So although it's arguable about whether or not, or the extent to which these dual audits are going to occur, one of the major issues that individuals are looking into when they're doing an audit of a health plan and of an employer is their fiduciary responsibilities. And if an entity for any type of service, whoever the vendor is, whatever the relationship is, you enter into an agreement which you don't understand the fees, then there's a possibility that you are acting beyond your fiduciary responsibilities, you're not acting prudently, and you're not managing the assets of the plan, which not only sets you up for a fiduciary breach, but also penalties.
Right.
So making sure that you're thoroughly not only reviewing these documents, making sure they reflect whatever it is that are your true intentions, but you understand them as a fiduciary of the plan. So that's why this is a crucial area of the ICE service that we have experienced. We've worked with so many of these different vendors that we can not only help you to unwind and figure out what it is that the role should be, but we can explain where the fees would be and how this works to the plan's favor. So this is something that's really important to be aware of. That's actually part of the ICE service.
That's a great point. One of the things that you have to remember as we go through all of these services is that, yes, if you, for instance, were to hire an attorney specifically to look at a contract, that attorney is going to look at that contract in a vacuum. They can ask you questions about your business, try to make sure that there's nothing that's going to run afoul of other obligations. But at the end of the day, they're looking at that contract whereas because of our relationship with you and the other things that we are doing for you as a user of, for instance, subrogation services or plan services, and because of our exposure to everything that's going on in the industry in general, we can look at a contract and language which on its own wouldn't be a problem, we realize may run afoul of a fiduciary duty as a plan administrator, or may be contrary to a potential network contract that you already have in place. So being able to point out those conflicts that don't just show themselves in the document, but have more to do with the document's relationship to other contracts, I think is one of the key benefits here. In addition, compliance questions, which we're going to talk about today, that's really, I think, the biggest value add when it comes to this service is being able to throw things to us, particularly these days when who even knows what the law is these days, right? So being able to say, okay, what do I need to do today to be compliant versus yesterday? TPA licensing questions and application process. We've actually had clients who are looking to expand into other states, are taking on new business, and they've had questions as far as, what do I need to do, who do I need to contact, and so we've assisted with that. FIA certification, looking at things like your plan document, ensuring that certain best practices are present, and basically putting our stamp of approval on it. And you would be amazed from the broker community, the TPA community, and most importantly, stop loss, excess loss reinsurance community and MGUs, when they see that something is FIA certified, it gives them a little bit more peace of mind and may actually result in savings from the actual rate that they're charging you. Claim evaluation. This is something that's very exciting and interesting for me. I like claim evaluation because it's real, you know. This is when you get an unusual situation, fact pattern, a claim in the door, and you're scratching your head, you're looking at the plan document, you're looking at the facts, and you're saying, look, I don't know what to do with this claim. You know, the group, they're saying, gosh, you know, we'd like to pay, but we feel like the plan doesn't allow us to pay. You know, if we were to pay the claims, would we potentially be breaching a fiduciary duty to the rest of our plan members? Well, gosh, I don't know. Is this a reasonable interpretation of the plan? Around and around it goes, bringing us in to add another voice and possibly help focus in on the issues and provide options. Claim evaluation is a ton of fun for us. Plan-related dispute resolution, same thing, live. This has to do with whenever there's any kind of a conflict between two or more entities, we want to know about it. We want to understand the origin of the conflict, not only to help come up with a resolution after the conflict's already occurred, but try to come up with a solution that will prevent these types of conflicts from coming up again in the future. So believe it or not, for every person out there who's benefited from a gap review between their plan and stop loss policy, it's because at some point someone had a claim denied, they brought it to us, we were able to negotiate a deal between the two, but more importantly, identify why the issue came up in the first place and come up with a solution that I think has saved everyone a lot of money, not to mention pain. And then again, appeals consultative assistance. This ties right into claim evaluation, assisting with appeals. The more complex, the better. You know, we not only here have a working knowledge of pretty much all the applicable laws and responsibilities, but I think we also have probably one of the most, I'd say, impressive networks of alliances and partners and clinicians and people who can look at very complicated medical and clinical issues and provide a clinical feedback as well. Nurses, doctors, certified IROs. So when you're working with the FIA group, you're not just working with the FIA group, you're also working with all of the friends and alliances that we've built over the years. That was a lot. That was a mouthful. So I'm going to turn it over to Jen now to talk a little bit about some of the really hot topics that people have been dealing with.
All right, thank you. All right, so the next couple of minutes, we're going to spend time talking about some of the issues that arise, some of the things that we run into as part of our consulting services, some of the common themes that we're running into as well. So to get started, obviously the first one is my baby, the plan documents, a template assessment, revising those documents, and even formatting. So as part of our review of different documents, people are sending us their materials, they're sending us their documents, and they're wanting us to provide an assessment. So when we're going through an assessment, which we'll talk about shortly too in more detail, there are a lot of different areas of the plan that we look at. It's not just limited to subrogation provisions or COB provisions. We're actually taking a cover-to-cover review through this assessment and looking at all the different areas in this document that could potentially create problems, whether it is something as small as a formatting or a cosmetic problem, or something as large as a compliance issue with one of the federal laws, whether it's not having the proper ERISA language in there or not having appropriate language about COBRA in there, and even something like cost containment, obviously, which is one of the goals that we have here at FIA, to make plans feel like they are empowered to make their own decisions and take affordability and keeping costs in mind when they're adding provisions and different benefits within their documents, and fully take advantage of everything they need to. So when we do these assessments, when people send these assessments to us, this is something that we very commonly see. There are a lot of areas within the document we're looking at. So it's important to realize that this is not a limited review, but it is specific to any type of issue that could arise to the plan. And more so than that, if someone wants to send us a document to provide an assessment, we can actually perform a limited review. So if getting a multiple-page document with all of our assessment items and all of our feedback and maybe suggestions on how something could be modified or addressed in the future, If there is one specific area within the document that you'd like us to look at, maybe you have a concern about the Medicare language that's in your document, you're not sure whether or not it complies with the Medicare Secondary Payer Act. Maybe you want us to take a look at that provision, that sentence, and provide you with our thoughts. So an assessment can really be how big or how small you'd like it to be depending on the question that you have or the question that the specific employer has. Next, we talk about enrollment and eligibility practices and some fraud concerns. So as part of this, there are a lot of, especially now when there are concerns about whether or not there is going to be a marketplace in the future and how that could exist. There are a lot of employers, a lot of individuals actually, who are concerned or unsure about their future or the sustainability of that marketplace. And they're not sure what to do. So they're considering whether or not they should enroll in their own plan or enroll in their own employer's plan. And thinking about that, there are timing concerns, particularly for groups that are not subject to the employer mandate. If you are a group that is not subject to the employer mandate, which still does exist right now, you don't have to have an annual open enrollment period because you don't have to meet the offer of coverage. So for some of these groups that have decided to not have an open enrollment period, an annual open enrollment period, what would happen if you just decided now that you didn't want to be on your marketplace plan, so you voluntarily decided to opt out of it, and the enrollment period is currently closed for your employer plan? How do you address that? What can you do? How can you add open enrollment? How can you do this in a way that wouldn't potentially be discriminatory or create problems for the employer? Also, another big issue that we're running into is talking about eligibility. A common question that we have been asked is, I want to make the cost of coverage more affordable. What is it that I can do? How can I carve out some individuals for my plan? What about dependents? I only want to offer this coverage for my employees. Well, we say, great, that's certainly something that you can do if you only want to offer coverage to the employees. But note, if you're subject to the employer mandate, that's going to be problematic because you have to offer coverage to your dependent children. But wait, that doesn't mean that you have to offer coverage to your dependent spouses. So there is an opportunity if you wanted to carve out a class of individuals from eligibility, you can carve out your dependent spouses. But how do you do that, you ask? There are lots of different considerations and things that you must keep in mind if you want to carve out your dependent spouses. First of all, you have to limit it to your dependent spouses. Second of all, you have to make sure that you are doing this appropriately from a timing perspective. You don't want to carve out dependent spouses at a time that would be suspicious if some employee's spouse is trying to enroll at that time frame. So maybe to avoid any issues of being discriminatory, you might want to do this at the next renewal period or at the next plan year. So you wouldn't have to have any questions arise about whether or not the timing for this carve-out would be suspicious. Another consideration that we've commonly seen, if you're trying to carve out particularly dependent spouses, is can you do this and say that I want to have a carve-out, but only if they're eligible for other coverage? Yes, certainly you can do that, but you would have to be very careful in how you craft that and how you administer that. Because if you draft this language and consider Medicare to be other coverage, that would be a violation of the Medicare Secondary Payer Rules. So you have to be very careful when you're carving out this. You're trying to carve out this class of dependent spouses and doing it in a way that would not be discriminatory, that would be compliant with the Medicare Secondary Payer Act rules. But also keep in mind, if you're adding this carve out for dependent spouses, that means that you're going to have to do some eligibility type audits that you may not have done before as an employer. So keeping that in mind, that by doing this, you may be potentially saving money by eliminating the class of individuals who are eligible, but there's going to be some additional administrative concerns and audits that will need to be added and to ensure that people are not being added onto the plan. Particularly to make sure there's not a situation where someone in that situation had coverage that they could have enrolled through their own employer, but they didn't do so. And you're thinking about that, and you have to make a decision about whether that individual who's currently on the plan that has a carve-out for dependent spouses who have their own employer-based coverage, are they enrolled in this plan fraudulently? Was it a mistake? Were they negligent? Did they not overlook it? Because remember, there are implications for enrolling in the plan fraudulently or for using plan benefits in a fraudulent manner. So there are a lot of considerations that an employer has to go through, and actually adding the language to a plan document to address a dependent spouse carve-out is the easiest part of this whole discussion. The next is a coordination of benefits issue. I just went into a couple of those when we're talking about dependent spouses, but when you are looking at a coordination of benefits issue, the major concern that we have, or that we're asked, especially recently, is how do I coordinate benefits with Medicare? What would happen if there was a situation where an employee is retiring at the end of the month, but they become eligible for Medicare at this date? Who pays first? And if I pay first as a plan, does that mean that stop loss is not going to reimburse me? Does that mean that potentially Medicare is going to come back if I decide that Medicare should have paid first and had issues or seek overpayment from me? So there's a lot of considerations when you're trying to deal with a coordination of benefits issue. So it's not limited to Medicare individuals, but also when we're talking about dependent children. So what if you have a dependent who is under 26 that's still enrolled in the plan? That dependent child has their own coverage, but that dependent child is also married and they're on their spouse's plan. So there's 3 different plans that you're trying to align and figure out who gets to pay first. So there's a lot of those difficult issues that we have a lot of experience and a lot of others have asked us. So in those types of situations, we're more than happy to provide you not only what we feel would be a compliant response, but a best practice as well. Next is state law applicability. So a lot of plans are municipalities or cities or counties, and they are subject to different rules than a standard ERISA plan. So you have to contemplate whether or not there might be a benefit or a rule that would comply. So oftentimes we get questions about, I'm in the state of Tennessee and I am a county. Is this rule going to be subject to me? How would this vaccine law apply to me? Are there any benefits that I might need to add because of this regulation? And we love those types of questions to do that research and see if there's potentially something that might exist that could be an additional benefit, a different offering that that plan might have to offer. The next issue is talking about discrimination, or I should say non-discrimination issues, as it relates to 1557 of the ACA. So if you haven't heard about this or haven't heard people talking about it, I'm not sure where you live, but this is a very hot topic that has been getting a lot of attention. So when we're talking about 1557, this is not limited to a transgender issue. 1557 is actually a much broader issue. So in addition to potentially having to offer or not exclude, not categorically exclude coverage, there are notice requirements, there are communication requirements, there are committee requirements that an employer who is subject to 1557 must comply with. So since there are so many moving parts and so many pieces of the non-discrimination rule under 1557, we'd love to address those questions to point you in the right direction, to provide you feedback about what we think the best approach would be for how to handle a question and issue, whether it's coverage or notices or something else. But I'm sure in those situations, any of your questions, we can provide you with at least a common sense approach on how to address it and what you should do as an employer, but more importantly, as a plan. Next, we get questions and issues about fiduciary obligations. A common example of this is when we're talking about the third-party contract reviews. So there are a lot of obligations that a fiduciary must provide for, they must do when they're related to a plan. They have to make sure that they're managing the assets prudently. They have to make sure that they are administering the plan consistently and not being arbitrary. And when you're looking at those obligations, you're not necessarily sure whether or how to handle a certain situation. Whenever those questions or situations arise through this ICE service, this would be something that we could provide feedback and comments and suggestions and next step action items for a plan or an employer who's stuck in a position where they're not exactly sure what to do next. I'm going to flip it to the, don't worry, there's more. There's more issues.
There are more issues? I thought we solved everything.
There's more issues, don't you worry. The next is talking about marketplace letters and appeals. So we've actually gotten quite a few questions, especially lately, about some of these appeals that have been arising that employers are facing. So right now, there is currently in place the employer mandate. So part of the employer mandate, an individual or an entity may be permitted to offer coverage, especially if you're a plan, you're required to offer coverage that is both affordable and meets minimum value. But separately and independently, individuals are permitted to go to an exchange and ask questions or to see whether or not they might be eligible for a subsidy. So an individual can go to the exchange, they can get potentially an eligible subsidy if they are eligible for it. And in that case, when they get a subsidy, the marketplace, HHS, doesn't necessarily know for sure whether or not that individual is eligible. So what do? They send a letter and say, hey, employer, you've violated the employer mandate rules because you have not offered this individual coverage that is both minimum value and affordable. And in that circumstance, an employer says, well, of course I have. Why am I getting this letter? Well, the answer is it's generally a form letter, and the most important thing to do in that circumstance is to respond to that letter and to not ignore it. There are certain time frames which we'll go into more detail talking about those, but you need to make sure that when we're talking about a marketplace issue and an appeal issue that you address it, you ask us any questions, and you provide more information as opposed to less information. Yes, and there was a question about whether ICE did include questions about COBRA, and the answer is yes. So if there are questions that arise about timing or something about whether or not an individual would be eligible for COBRA, especially if there's not math, though. That's the only caveat. There can't be any math. Unless it's easy math, then Ron can do it. But yes, ICE does include questions, general questions about COBRA. And obviously, as part of the ICE service, send us everything, and we'll let you know if it is something that we can't answer. But regardless of the scope of the question, so for example, we can't handle custody issues. That's not something that's outside the scope of ICE. I don't know why that came up. But
although if I feel passionately about it, that might help.
But yes, we do answer questions about COBRA. Another issue is talking about the plan status. So if you are an employer and you have a plan, are you grandfathered or non-grandfathered? And obviously everyone who had a plan as of March 23rd, 2010, that's such a long time ago,
I know,
may have been grandfathered at some point. But over the course of the past 7 years, it's possible that you have lost that status. So as part of the ICE service, you can send us questions or say that I'm changing a copay from $5 to $500. Will that cause me the loss of my grandfathered status? We can address those questions. So we can't actually make the determination for you that you are non-grandfathered or still grandfathered. There's no certification that corresponds to that. We can certainly provide you feedback and guidance and our thoughts about whether or not a change that you are trying to implement could cause the loss of a non-grandfathered plan or could cause the loss of your grandfathered status and put you under the plan status of non-grandfathered. And really why this matters is because there are certain rules that a grandfather plan has delayed enforcement of. So some plans, I'm not sure that there are too many at this point, but there are some plans that find that it is more important for them to keep their grandfathered status than to change provisions within their plan that may actually be more cost effective than maintaining the grandfathered status. Obviously, there are certain things like offering 100% preventive care coverage that could potentially be more costly, but don't we want to encourage people to get preventive services so they're not diagnostic or reactive services? The next issue is health reimbursed HRAs, FSAs, HSAs, cafeteria plans, all the good stuff. So all of these tax vehicles, I love tax, obviously, because it involves math. What do I do, though? So we are actually starting to get a lot of questions. There's been a lot of talk, especially with the current administration, about whether or not how these vehicles can be taken advantage of. Now there's new rules for a small employer who can take advantage of these HRAs. So we're getting a lot of questions. We love addressing these types of questions because this is a new opportunity for an employer to potentially offer a plan and to help them to stay self-funded because they can take advantage of these vehicles to lower costs for benefits or qualified medical expenses. So as part of ICE, we're happy to address any questions that might arise relating to those issues. The next issue is a stop-loss denial review. So oftentimes we get questions about I have a claim and my claim was payable under the plan, but stop-loss denied it. What do you think? Can you provide me your thoughts? Well, obviously, in those situations, we'll need more than just the facts. We'll need the stop-loss policy. We'll need the plan document. We'll need any sort of network agreement, any other correspondence or emails that had transpired up until that point, a chronology of the events. But after we have all that information that's crucial to reviewing this claim denial, we can provide our feedback, our thoughts, our commentary about whether or not we agree or disagree, or whether it's before the actual denial or after it's already been denied. And one of the benefits of working through ICE to use a service is that we are providing an unbiased opinion. So we are not changing our opinion whether or not a plan asks us, an administrator asks us, or a stop-loss carrier asks us to review this specific claim denial. We're providing the same unbiased, objective opinion regardless of who the requester is. The last but not least issue here is the ACA and mental health parity, talking about rules with the essential health benefits. So you may or may not be aware that there are certain benefits that are considered to be essential. And mental health benefits and substance use disorder benefits are considered to be essential. And if you are an essential health benefit, that means that there can be no dollar limit that is applied to those benefits. So while we know that those benefits are essential and we cannot apply dollar limits, and that's the rule under ACA, there also are mental health parity concerns as well that adds a different layer or an additional layer of complication of how to address these issues. So it's important to have those addressed compliantly and consistently, and through ICE, that's certainly something that we can address. I turn it. Oh, case studies. All right. So to give you an idea, some real-life examples of how ICE has come in handy, we're going to give you three main issues that we have run into. The first issue is going to relate to our plan doc assessments, formatting, and revamp services. The second is going to be a marketplace letter and appeal example. And the last, but certainly not least, is the ACA mental health parity and EHB overlap, how to handle those types of issues.
I can't wait. This is exciting.
All right, let's get started. Case study 1, assessment, certification, revamp, and formatting. All right, so like I mentioned before, we have a lot of different plan document services that we offer here, and ICE gives the benefit of supplementing all those services by getting all of the questions addressed and answered so you have a cohesive, compliant plan document. So specifically, we have a certification service. And our certification service is for people who like things to be short and sweet. And as part of the certification service, we have a laundry list of items that we will review for within a document. Certain items that are of compliance concerns or cost containment concerns, and we essentially run through the document, crossing them off yes or no through the list, saying yes, it has fiduciary language, yes, it has discretionary language, yes, it complies with it has the SPD requirements in here. So there are a lot of different items that we're reviewing for. We'll give you a check, 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 pass, or check, check, no, fail. And as we were going through and doing one of these certifications, we got all the way through a list almost until we got to the benefits. And we're taking a look at the benefits. And specifically in this plan, there were some dollar limits that had been placed on a benefit. And we gave this specific plan a failing grade. They didn't get the certification. They didn't get the FIA certification that everyone wants and needs. So we provided back the report card with the failing grade. And we said this plan didn't meet the requirements because there are dollar limits that had been placed on the chiropractic benefits. And the plan had, in that case, that employer had selected the Connecticut benchmark. And in Connecticut, chiropractic benefits are considered to be essential. And under ACA, if you have essential health benefits, like chiropractic in Connecticut, you cannot have any annual dollar limits. So it was a violation of the ACA and the essential health benefit rules in that case for that self-funded plan to apply those limits because they had picked Connecticut as the benchmark. So as a quick reminder, plans do need to specifically select a benchmark plan when they're deciding what is essential and what is not essential. So the employer came back to us and they said, well, I want to have these limits. This is a great benefit that we offer to our employees. A lot of employees take advantage of it. What do I do? Well, just because you have to pick a benchmark doesn't mean you need to pick the benchmark of the state that you're in. So you have the opportunity to look at all of the different state benchmarks, there's 50, and you can pick from that list and find one that most specifically aligns with the benefits that you want to offer. So in this case, we took a look, we said, we know that you want to, here are the items that you want to make sure that you can have dollar limits on because you want to offer this benefit, you don't want to not have to offer this benefit. Connecticut's not going to be workable because in this case, they have Chiro as one of the essential health benefits. So what do I do? So we started looking through Alaska, start with the A's, and when we got to Utah as an example, which is generally the state that has a benchmark that has the fewest amount of benefits, it's not as rich as a state like Massachusetts or Connecticut. If the plan had, instead of picking Connecticut, if the plan had selected Utah, they could still retain those dollar limits on the chiropractic benefits. So by noting and documenting that this plan instead was complying with the Utah benchmark and selecting Utah as a benchmark plan, they could keep their Chiro benefits and they could keep that dollar limit because in Utah, Chiro is not essential. So that was a great way that we could take advantage, a plan could take advantage of the certification service in order to identify a potential issue, but not only identify an issue with their plan, resolve it in a way that would be favorable for them. All right, let's move on to the next one. Marketplace letters and appeals. So I know I talked about this one a little bit. This is an important issue because there are consequences to not responding or not addressing these specific issues, specifically the marketplace letters and appeals. So as there are a lot of questions that are arising, a lot of entities, individuals are rushing to the marketplace to take advantage while it exists. Maybe it won't exist, maybe it will, who's to say the future? And there are a lot of entities, individuals that are going to the marketplace saying, sign me up for coverage. And by the way, I want a subsidy. So as the marketplace is receiving all these requests and all these individuals are trying to determine whether or not they might be eligible for a subsidy, which is dependent upon what? Whether or not the employer had offered a plan that met minimum value and was affordable. So when they're getting all these requests to decide, to determine whether or not an individual is eligible for this subsidy, they're not sure what to do. They're not going to have any idea about whether an employer had offered coverage which was affordable and met minimum value. So what are they to do? Send you a letter. That's what they're going to do. They're going to send these employers, send these plans a letter saying, here you go, this person was eligible for a subsidy and you violated the rules by not offering a plan that was both affordable and minimum value. That throws the ball in the employer's court to make their case, to prove it, to say that the plan that they had offered to that individual specifically met all the requirements. So this is not something as simple as saying, here's my plan document. It's much more than that. You can't take a plan document and alone use that as proof that the plan was both affordable and met minimum value. This is going to require showing that there was an offer of coverage to this individual, to determine that this individual in this case had maybe waived this coverage. Is there any sort of email or documentation or dates that you can prove that it was both offered and then waived? Can you show a pay stub for this specific individual that says that this plan is using the W-2 safe harbor as for their determination of affordability? And in this case, did that employer use that safe harbor? Is it documented that the payroll, from the payroll stub, that they paid X amount of money for coverage and that was affordable in this case? So it's going to be really important when you get these letters that you respond within the strict time frames that you have, they have set out for you, but also you provide more than enough information so that the marketplace can't come back to you and say, sorry, not enough information, because in this case, with these letters, there's one bite at the apple. So if you do not provide the information, get it, the letter in time, respond in time, you're going to be subject to a penalty. So it's really important that you respond and comply and provide us information so you can avoid these penalties. I think that more often than not, you're actually going to see these letters. They're form letters that you're going to see from the marketplace, because this is the only way right now that they can really verify whether someone's eligible for a subsidy or not. All right, let's move on to the next one. ACA and mental health parity. Okay, so I talked about this one a little bit. So there are a lot of rules that self-funded plans have to comply with. And oftentimes, like wellness plans, which we're not specifically going to talk about today, there's a lot of overlap and even conflict about how to apply a group or multiple groups of rules to the same plan, particularly to the same benefit. And this really arises when it comes to mental health and substance use disorder benefits. And why this is something that we're talking about now is more so because a lot of these claims we're seeing come in, particularly those for residential treatment facilities. There are a lot of employers who, I'm not sure if there's in the area a lot of commercials or radio ads or somewhere that's advertising for a treatment facility. Come here, I had an opioid addiction, but I went to Promises and I'm fixed, I'm great, you should call, your insurance is going to pay for it, no problem. So after seeing maybe these ads or hearing about this or hearing a story from someone, a lot of individuals may be more taking advantage of these services than they had in the past. And that begs the question for the plan, oh, I didn't ever really specifically address residential treatment facilities before. Is that something that is under my plan? Is that something that's covered? Is that something that I am eligible for? Can I have those benefits covered? And we're seeing a lot of plans and getting this question a lot, and unfortunately, this is not something that's actually even really addressed in a ton of plans, or this was something that they offered on a case-by-case basis and it wasn't necessarily clear. But to comply with the rules, it's going to be important that if a plan offers skilled nursing facility coverage and a plan offers rehab hospital services, that you also have to cover this residential treatment facility coverage, and you do so in a way that's going to be in parity, because that's the other piece, important piece of the mental health parity rules, that you offer the benefit, but you offer the benefit in parity. So there is not a discrepancy between maybe the skilled nursing facility visits limited to 90 visits per year, but the residential treatment facility visits being limited to 30 visits per year, because that is not in parity. So it's really important, especially now with the overlap of the different ACA rules, the mental health parity rules, whether or not it's essential health benefit or not, that you take a really good, hard look at the plans, or more importantly, use ICE to email us and ask us to take a look at your plans specific to this issue, because you can imagine that this is a hot topic, people are talking about it, so it's something you need to pay attention to now.
So hopefully at this point, and Jen, thank you very much. That's a lot to get through in a short period of time. But hopefully for those who are dialed in at this point, you recognize that these are issues that are impacting you or your clients, whether you brought those to our attention or not. These are the types of questions and issues that are being brought to us as an independent consultation and evaluation provider. The way to submit these questions, and this is one area of confusion that I want to make sure I nip in the bud, we, like an arena, have multiple entrances into the same building, and we welcome those questions and referrals however you can or feel most comfortable submitting them. I will make it absolutely clear at this time, however, that every client for our ICE services is provided with their own custom ICE email address. Ordinarily, it's the company's name -ice@fiagroup.com. And we ensure that everybody who is either going to manage your account, answer the questions, or have access to our network of affiliates is on that email address. So that this way, unlike situations where, and we've all been there before, you email one person or leave a voicemail for one person and they're on vacation and it sits unanswered, that will never happen here. So please feel free to contact whomever it is that you feel comfortable contacting, but if you are an ICE client, utilize that tool. We've built it just for you. Real quickly also, as an ICE client and a partner, I just want to make you aware of some of the special products that we're brewing, new services that we're preparing here. Again, as an ICE client, you're going to be one of the first ones to hear about these things as they hit the market. The first is our flagship. Basically, over the years, what we've always done is really promoted the benefit of self-funding, or one of the benefits of self-funding is your ability to customize your plan document. And unlike a lot of the cookie-cutter solutions out there, our plan document software really gives you multiple options when it comes to populating the document. We're nerds, we're geeks, we're dorks when it comes to plan documents and self-funding and ERISA. So maybe we look at a 500-page template with multiple options and we think to ourselves, wow, you know, this is awesome. Look at this, 12 different ways to phrase a workers' comp exclusion. This is the best. But for a lot of people who are not necessarily in the business and are just looking to get a plan document made, it could be overwhelming. And, you know, so sometimes it's almost, it's an abundance of wealth to the point that you're overwhelmed. So what we've done is we've created almost, if you could imagine, the FIA plan document with a filter, and it says FIA's best practices. You click that, and it selects the options wherever possible that we think are best practices or best, the tightest language for the plan document, and it really trims down the template to a much more manageable template. And of course, if you're looking at the document after it's been populated and ready to go, and you see something and say, well, that's FIA's best practice, but I would prefer a change, we can always make the changes after the fact. This is not a take it or leave it approach, but rather a quick way to populate the document, pick the options that we think would be best practices, and then you can just run through it and say, you know, I'd like to edit or revise a couple small things, but most of the work's been done for me. Speaking of documents that need to reflect your intent, no matter how hard we try, employers, plan sponsors, plan administrators, we want them to treat the plan document as something that is important, that needs to be addressed, you know, year after year. This is the most important thing you're going to do. Pay attention to me, please. But at the end of the day, they don't care about us. I know.
No.
You know, everyone on the phone is like, no, this can't be. They don't care about you. They don't care about us. The plan document, that's somebody else's problem. I've got a broker. I've got a TPA. I've got an ASO for that. I don't need to address that. I'm focused on HR. I'm focused on my employee handbook. That's where I express my intent to my employees. And all too often, these organizations, these employers, you know, good for them, they're changing their handbook. They're offering robust benefits. Like I mentioned before, they're extending health benefit coverage to those who are disability on leaves of absence, and they forget to amend or update their plan document, and they end up in big trouble as a result. So it really is our responsibility to tell our clients, these employers, hey, listen, do what you want in that handbook, but make sure two things are happening. One, somebody's reviewing the handbook to make sure what you're doing is legal in and of itself. And two, ensure that that handbook mirrors the plan document, your stop loss, that you're not necessarily making promises to your employees that your plan document can't keep.
Wait, Ron, are you saying that the only way to offer coverage during a leave is through the plan? Dun, dun, dun.
Dun, dun, dun. All right, so listen, you gotta sign up for LinkedIn. The number of interesting stories, news stories that we're publishing every day on LinkedIn that we're sharing with our connections, you know, it's your one-stop shop for all the information. But more important, the connections that we already have, some of the interesting comments and banter that comes up in response to these news stories is way more interesting than the news itself. So if you're interested in seeing what your colleagues actually think about some of this stuff, but they're afraid to say out loud, but are more than willing to type and put in writing, and that you could copy and share with all your friends and expose them for the wackadoos they are, you have to sign up on LinkedIn and see what's going on, not only in the industry and what people in the industry think about the news, but also to hear about what we're thinking, what we're working on, and what's next down the pipe. I just want to take this moment to thank everybody who signed up for this webinar, for ICE, for those of you who have these questions and concerns constantly coming up and you're thinking, I can't submit them to FIA Group, it's too much, they're going to charge me per question, they're going to charge me per hour, and eventually it's going to cost more than it's worth. You need to utilize ICE because this is a prepaid subscription. We want you to pay, we want you to subscribe, and then it's an open door. You send us whatever questions, issues, concerns you have. the more the merrier, not only because it gives us an opportunity to help you and strengthen the industry, but also because it allows us to come up with new solutions for other people who have not yet been impacted. As an industry, it's our job to help each other, because for every third-party administrator, ASO, or anyone who advocates for self-funding, when we look bad, we all look bad. When one of us looks good, we all look good. Right now, the spotlight is on us. Is this an industry that's going to remain? And the only way that we're going to be able to say to regulators and politicians and lawmakers that self-funding is a good way to provide health benefits and it should be protected rather than eliminated is if we avoid embarrassing issues, concerns, and conflicts, and this is one of the ways we're doing that. So again, thank you so much, everybody. We hope to hear from you soon.